Welcome to the Labor and Employment Podcast Series. This podcast will address technology and workplace compliance problems by Eric Athey, attorney at law. Mr. Athey is the co-chairman of the Labor and Employment Practice Group at McNees.
When the use of email in business became popular in the mid-1990s, the employment law implications seemed simple. Employers were primarily interested in knowing whether they could implement policies restricting employee email use to business purposes and whether they could lawfully monitor usage to ensure compliance with these policies. As business uses of technology have expanded over the past 25 years, these initial legal concerns have spun into a multitude of compliance issues. All attorneys who represent businesses are wise to have at least a passing knowledge of these technology-based compliance traps. This podcast discusses some of the primary employment law issues that can arise from technology in the workplace. Let's start with the first phase of the employment process, hiring. You just interviewed a great candidate, and before you draft the job offer letter, you decide to Google her name to see what sort of web presence she maintains. There you may find social media posts from your candidate, which she discloses her age, religion, medical history, feelings towards unions, etc., all of which you could not have asked during the interview. Complicating things further, some social media sites give her the ability to determine whether you viewed her page. Now, if you decide not to hire her for other legitimate reasons, say a problematic criminal history report, she may claim that the decision was based on unlawful considerations that you've identified during your web search. Your search was not unlawful per se, but it may add fuel to a discrimination claim. To prevent this conundrum, employers should have a protocol defining how background checks are conducted during the hiring process. These policies often prohibit hiring managers from casually searching the web regarding candidates. Technology can also present challenges for employers under the Americans with Disabilities Act. For example, a customer service representative claims that he needs to work from home due to an unusual sensitivity to scents in the workplace or due to anxiety. 25 years ago, it's unlikely he could have performed the essential functions of his position at home. However, with today's technology, it's often just a question of whether the employer is willing and able to invest in an at-home workstation to accommodate him. Many factors affect whether this investment is required as a reasonable accommodation under the ADA, such as the cost or size of the employer, and the ultimate determination should be made only after researching the options and engaging in interactive dialogue with the employee. Telecommuting is not feasible for all positions, but employers shouldn't reject technology-based requests for accommodations without careful analysis and some interactive dialogue with the employee. Let's turn now to the National Labor Relations Act. Over the past 8 years, the intersection of technology and the NLRA has routinely made headlines. The National Labor Relations Board has issued a series of opinions limiting the ability of employers, both unionized and non-union, to discipline employees for social media posts that are critical of the employer. In a nutshell, the NLRA protects the rights of employees to engage in protected concerted activities. So if two or more employees engage in a public Facebook discussion on how horrible their employer is, their activity is often protected by the law. However, social media is only one example of how technology can create issues under the NLRA. Another prominent issue is the extent to which an employer may prohibit employees from using company-provided email to engage in union activities, such as organizing a union meeting. Yet another common issue is whether a unionized employer has the right to unilaterally implement technology that monitors employee behavior and to render disciplinary actions based on the data it generates. All of these issues deserve careful consideration under the NLRA before moving forward. It's likely that the board's position on these issues may shift a bit under the current administration in Washington, so it'll be important to stay tuned on that front. Failure to understand the implications of business technology under the Fair Labor Standards Act can quickly generate substantial wage liabilities for employers. Smartphones and other personal electronic devices are the primary risks here. By way of example, an hourly technical support employee is expected to respond to questions from customers or supervisors within an hour after they're raised. If an employer knows or should know that the hourly employee is responding to these questions outside of normal working hours via the smartphone, the employee must be paid for the additional work, and that might be at an overtime rate. Notably, the U.S. Department of Labor has developed a smartphone app that enables employees to track their off-the-clock work for the very purpose of holding employers accountable for these extra hours of work. Class action wage and hour litigation is a burgeoning industry for plaintiffs' attorneys, and wage claims for off-the-clock work is one of the leading compliance problems underlying these lawsuits. The cautious employer will have a policy in place that strictly limits off-the-clock work and that requires employees to promptly report any time they happen to work outside of their normal working hours. Closely related to FLSA concerns is workers' compensation liability. If an employee is engaged in off-the-clock work by responding to customer calls and emails after hours, chances are that any injury they may sustain during that time would be covered by workers' compensation. The classic example here is the sales employee who takes a call from a prospective customer while driving. In many jurisdictions, if the sales employee wrecks his car while engaged in a work-related call, his injuries will be considered work-related and compensable under workers' compensation laws. Since the employee was acting in furtherance of the employee's business at the time, his employer may also be liable to injuries sustained by third parties. Many employers have responded to these liability risks by prohibiting use of cell phones while driving, or perhaps requiring the use of hands-free technologies for such calls. Back when email was introduced to most workplaces in the 1990s, the primary legal concern was the extent to which employees had a right to privacy with respect to the emails they sent from work. In most jurisdictions, employers are free to monitor employee use of the company's electronic resources to ensure compliance with these policies and requiring appropriate usage. A good usage policy will notify employees in clear terms that their usage may be monitored and that they should have no expectation of privacy. A notification of this nature should reduce the likelihood of privacy claims. However, what if in the course of monitoring business email, the IT department comes upon highly sensitive personal information relating to an employee? Perhaps an email exchange indicating that the employee was recently diagnosed as HIV positive. Courts in several jurisdictions have held that employers must immediately stop reading once they realize they found personal email communications on company servers. Reviewing the content of some personal communications after it's already been determined that they're personal in nature could support an invasion of privacy claim in some jurisdictions. Both HR and information technology staff need to understand this. One common thread of all the risk scenarios outlined above is that in each instance there will likely be a traceable electronic history that may support the employer's defense against liability or may blow it out of the water altogether. With the advent of electronic discovery, many unwitting managers have learned it's hard to keep a secret in the electronic age. A manager accused of sex discrimination will have a difficult time disowning the offensive jokes and comments that he's made about female coworkers to his male friends via email. The risks presented by electronic discovery compel employers to develop and enforce well-crafted technology policies which anticipate all of the risks discussed above, and to train and periodically remind employees regarding appropriate usage. Any good training program will highlight the worst-case scenarios that electronic discovery can easily make a reality. The rise of electronic technology in the workplace has generated a wide range of compliance risks that employers could not have imagined 25 years ago. As any labor and employment lawyer can tell you, the issues outlined above just scratch the surface. Technology presents new employment law issues nearly every month, and this is likely to continue for the foreseeable future. Yet for each technology-based compliance challenge, employers can limit liability by proactively gaining an understanding of the compliance risks presented by new technology, developing or updating a well-reasoned policy that is tailored to their operations, training and retraining employees, and vigorously enforcing their policies. This disciplined approach will allow employers to capitalize on their investment while avoiding the legal landmines we've discussed here. For more on this topic, please see the information on the next screen.